Thank you, Mr. Chairman, very much. In Massachusetts and communities across the country, we have an epidemic of heroin and prescription drug overdose that is absolutely out of control. Buprenorphine is the active ingredient in Suboxone and has proven to be an effective treatment for opioid use disorders. However, actions by Indivior, the producer of Suboxone, may have made the crucial drug less accessible as a treatment to deal with this problem. Indivior is alleged to have violated antitrust laws by conspiring to block generic competition, extending its monopoly over treatments for opioid addiction and driving up drug costs. 35 states and the District of Columbia have recently filed a lawsuit against the company, and public documents show that the Federal Trade Commission has begun an investigation into Indivior's actions, but the investigation was significantly impeded by the company's repeated attempts to deny the Federal Trade Commission access to documents that were critical to its investigation. And it now appears that the court has recently ordered Indivior to turn over all remaining non-privileged documents. Now, I've sent a letter to the Federal Trade Commission on this issue to investigate whether or not Indivior has engaged in unlawful behavior to delay the approval of cheaper generic competition, which could help deal with this incredible epidemic of heroin, prescription drug, fentanyl overdoses in our country. Do you have enough resources at the Federal Trade Commission to be able to take that issue on and to get it completed in a timely fashion? We just see a spike across this country. We need more help.
Senator, yes, thank you for your question. I had an opportunity to talk a bit earlier about the importance of examining and monitoring the pharmaceutical marketplace, and I can assure you that we're very active. I can't comment on the specifics of any investigation, but I can tell you that we are certainly doing everything that we can with our resources. We could, of course, always use additional resources, and we've made appropriate requests from Congress with regard to our budget in order to fulfill our dual mission of protecting consumers and promoting competition. But what I can tell you with our existing resources, we're doing everything that we can.
And does that mean that you are right now aggressively pursuing Indivior and its attempt to control the market for buprenorphine?
All I can say publicly is to let you know that we certainly are continuing with our investigation, but unfortunately, due to confidentiality restrictions, I can't say more than that.
Okay, let me move over to child privacy. Right now, as Senator Daines pointed out, the existing law, which I'm the author of in 1998, protects children 12 and under and their privacy. Can you give us your view as to whether or not children 13 to 15 are entitled to the same kinds of protections as those that are 12 and under?
Under current laws, as you've noted, it does apply to those children that are under 13. As I had an opportunity to discuss earlier, I do think that it would be appropriate to address issues particularly relating to education and information about students. And in that regard, I think appropriate protection would be beyond the age of 12. So I think there are areas where Congress may want to take a look and see if it's appropriate to have further protection.
Do you think that the parents of children 15 and younger should have an eraser button, which they're able to have all these companies that erase the information about their children 15 and under, so that mistake that the child may have made doesn't track them for the rest of their life?
I think one can discuss where one draws the line appropriately for protection of children. I am certainly sympathetic and supportive of efforts to provide additional protection to children, given, of course, the indefinite nature of information that can be posted online, so that I'm generally supportive of efforts to look at that issue. Okay,
thank you. And now that the question of whether broadband is a telecommunications service under Title II was strongly settled by the D.C. Circuit Court, the Federal Communications Commission is correctly extending privacy protections to broadband. It's clear that the Federal Trade Commission and Federal Communications Commission both have clear roles to play as privacy cops on the beat. But now that the broadband privacy issue is in the basket of common carriage, which the Federal Trade Commission does not have jurisdiction over, the Federal Communications Commission must act without delay to put in place strong broadband privacy rules. And do you agree with that, as that they are the principal agency responsible for that issue?
Yes, in light of the reclassification of broadband service, the Federal Communications Commission is the one that has jurisdiction here. I do think it's appropriate for them to put in place appropriate privacy rules. We have, as part of their rulemaking process, submitted comments in which we've opined as to what we believe would be improvements to what they've proposed.
Okay, thank you, and thank all the commissioners for your great work.
Thank you, Senator Markey.